2 in the matter of Dulgheriu and another and London Borough of Ealing, part 3rd.
I suppose an issue has arisen due to the searches conducted overnight, which has led to, I'm going to invite now my lady to ask Mr. Havers a question relating to his submissions.
Mr. Havers, probably a small point, but you will recollect yesterday afternoon when we were looking at the wording of the order and the terms in which it's expressed. And I posed the question whether or not it was the sort of general similar wording to that which is used in non-molestation orders, which of course are different because they're directed to an individual and not subject to our issues about Articles 10 and 11. But I have overnight obtained the standard orders that are used in non-molestation cases, and it occurred to me that really you ought all to have an opportunity just to have a look at those in case it led to any further submissions, or it was something that we ought to be considering when looking at the breadth of those orders. So what I've got is I've got the book which I'll pass down. It has got large amounts of red, which are for people to insert the various alternatives. Unhappily, the judges don't have access to colour printers, so the copies I've done for you are in black and white, so perhaps we can pass those down and you can have a look at them or review at your leisure. It may take us nowhere, it may be of some interest. Thank you very much.
Thank you very much. Yes.
My ladies, I turn then to the first ground of appeal, and before addressing the specific ground, may I make 6 points about the statutory scheme. The first is that PSPOs are designed to be used by local authorities to address matters of local concern, to be used flexibly and putting victims at the heart of its response. And I take that from the frontline statutory guidance, which may I ask you to take up, please. It's tab 5 of the authorities bundle, and then it's page 26 of the bundle itself. You were taken to part of this yesterday by the learned friend.
Which tab?
It's tab 5, my lord. Page 26. And it's within the introduction, and the penultimate paragraph, just after the paragraph referring to powers being deliberately local in nature, says the first part of this guidance focuses specifically on putting victims at the heart of the response to any antisocial behaviour. We know that when left unchecked, antisocial behaviour can have an overwhelming impact on its victims and in some cases on the wider community. And then the first sentence, 2 sentences of the last paragraph states, the second part of the guidance focuses on the use of the powers provided by the Act. These are designed to be flexible to ensure that local agencies have the tools they need to respond to different forms of antisocial behaviour. And I do note a couple of other points about the statutory guidance. If one looks on page 27 in the table headed Public Spaces Protection Order, you'll note that under purpose, the purpose is correctly stated by reference to the statutory terminology, namely antisocial behaviour in a public place, as is the test. No reference to community in either of these parts of the guidance. And I would also note that on page 29, at the top of the page under details, where it says the legal tests, the guidance says the legal tests focus on the impact that antisocial behaviour is having on victims and communities, distinguishing between the two. And the final point to make about the guidance, which I'll address in one of my other points about the Act, is one sees under where can it apply. It notes the definition of public space is wide and includes any place to which the public or any section of the public has access, or on payment or otherwise, as a right by virtue of express or implied permission, for example, a shopping centre. So we're considering a very, very broad scope of public place. So, ladies, that's the first point. The second point is that authorities have a very wide discretion to decide what behaviour is troublesome in their area and what controls are necessary. And this is the very essence of local politics. And I take that from the judgment of Mrs. Justice May in the Summers case. You were taken to a couple of paragraphs in that, but not this one. It's tab 22 of the authorities bundle at page 624. And may I just ask...
22 of the authorities bundle.
Yes.
Tab or page?
Tab 22, page 624. Sorry, Mother.
Yes, thank you.
And it's paragraph 25. And may I ask the court to read that paragraph? It doesn't, unless you wish me to read it out.
Paragraph
25, please. And I accept, of course, that that can only go so far, because in this case, convention rights are engaged, and therefore the court itself must undertake the proportionality assessment. But nonetheless, these are local provisions, the essence of local democracy. The third point is that although the statutory guidance gives examples of controlling the presence of dogs and restrictions on alcohol, it's clear that the powers have great breadth. Because, for example, we see within section 72 that particular regard must be have to articles 10 and 11. So Parliament has clearly contemplated that these orders may be made in cases which do restrict people's freedom of expression or assembly. The fourth point relates to the public place definition. And when I take you to the definition, it's within tab 1 of the authorities bundle on page 11. And it's within section 74, and it provides public place means any place to which the public or any section of the public has access on payment or otherwise as of right or by virtue of express or implied permission. And so, as the guidance suggests, it includes shopping centres, it would include places of entertainment, such as Alton Towers, Kew Gardens, or Hampton Court Palace. Of course, there would be a requirement to consult with the owner or occupier in advance, and we see that from section 72 4C, where there's an obligation to consult. But nonetheless, it is a very broad definition of public place.
But what's that got to do with this appeal?
My Lord, because the point is that it contemplates there are going to be public places which by definition are ones where everyone who goes there is going to be a visitor and who may well be there only on one or two occasions. And it's very difficult to contemplate a community in the sense that my learned friend's submissions put forward, where one could deal with problems within Alton Towers or Kew Gardens, where those problems are faced by the people visiting that public place itself. My Lord, the fifth point concerns the relevance of the fact that the making of an order criminalises otherwise lawful conduct and an offence is created subject to the defence of reasonable excuse. But my Lord, that of course is no different to any bylaw made under any other statute. Each of those create criminal offences, each of those have financial penalties, and indeed our submission is that it is appropriate to regard the PSPO as a modern form of bylaw. And in support of that, I'd ask you to note section 70 of the Act, which we have on page 8 of the tab, which provides that a bylaw that prohibits by the creation of an offence an activity regulated by a public spaces protection order is of no effect in relation to the restricted area during the currency of the order. So it appears to be that it takes the place of a bylaw.
Well, that may be also that. Do you reject the proposition that where there is conduct which is criminalised, that the interpretation of it must be a more strict one than would otherwise be the case?
But I do. I mean, in Liberty's submission, they appear to run with what was then ground 2 of the appellant's case. Namely, there needs to be a merits approach to the statutory requirements. That is no longer the appellant's case. But Liberty appear in paragraphs 5 to 8 to say that the court must have anxious scrutiny in a case where there is any criminalisation of conduct. And they rely upon Bugdeke for that proposition. But we say that that's not right. This is no different to any other case of a bylaw, which means that conduct that was otherwise criminal is to be criminal. We accept, of course, that when one comes to convention issues, it's an entirely different analysis. But we don't accept that this is anything other than the ordinary Wednesbury test when one is looking at whether the requirements of the Act are made out. In further support of that last point, I would note, of course, that in terms of the offences section, section 67, not only is there the defence of reasonable excuse, but there is also an additional statutory defence in section 67(3), which provides that a person, so it's page 7, a person does not commit an offence under the section by failing to comply with the prohibition or requirement that the local authority did not have power to include in the public spaces protection order. So it's giving, in statutory form, a Boddington-style defence that was always available to those who were alleged to have breached bylaws, namely to say this is simply not within the scope of the power. My Lord, the final preliminary point goes to the court's power to quash, which I thought it'd be useful if I set out what our position is on approach at this stage, although in our submission on the scope of the order, etc., substantive points will be made. So, my Lord, the section is 66(5), and I won't repeat it, but we would submit that the way in which it operates is as follows. Firstly, if the court is satisfied that the authority did not have power to make the order in its entirety, then clearly the power is to quash the order itself. Secondly, if it is satisfied it had power to make the order, but equally satisfied it did not have power to include a particular prohibition or requirement, then the power to quash is a power to quash that particular prohibition or requirement and otherwise leaving the order intact. That brings one to the third point, which is what does the reference to any particular prohibition or requirement mean? So, for example, to take paragraph 4.1 of the order in this case, which contains a number of elements of conduct that are prohibited, and take prayer. Now, if the court was to conclude that all of the remaining part of paragraph 1 was fine, but that prayer was not warranted, would the court be required to strike out all of paragraph 4.1 or only the offending word prayer? And we would submit that it would be the latter, that in effect it's a blue pencil test. What the court should do is it should strike out that and only that which it considers there was no power to make the order, and so long as what remains can be read sensibly, that is the extent of its powers. We say it wouldn't be right, for example, on that paragraph, if everything else was fine, but there was one provision that was wrong, that the whole thing has to go. It the greater includes the lesser. Having said that, we accept, of course, there is no power to vary, and the court cannot rewrite the order. It can only delete words. But we say that if one can delete words, and if what is left can then sensibly be read, then that is sufficient. Well, the fourth point is that this is a case where the prohibitions and requirements interfere with convention rights. And so we accept that they cannot be more extensive than is necessary to protect whatever competing convention rights are in place, either Article 8 rights of the service users and or any other rights or freedoms which
Can it be more extensive than necessary to what to you're going quite fast.
I'm terribly sorry, my lord.
Necessary to
Necessary to protect the competing convention rights that the court is satisfied hold the balance. And we accept also that the onus is on the respondent to satisfy the court that each provision is not more extensive than is necessary to protect those competing rights. So far as the court is concerned, we do submit that it is required to make an assessment of each provision in the light of the evidence and its conclusions on which rights are engaged, how they are interfered with, and how they need protection. And it must undertake that analysis for itself, because it can only do that. It can only then reach the conclusion that a particular provision is not warranted without that prior analysis. If the court does consider a particular provision is not warranted.
So the way the structure works is you say whether or not there is power in the local authority to make the order as a matter of what they used to call varies, but authority, is to be determined on ordinary judicial review principles.
Yes.
Once you get to the stage that there is power in the local authority to make the order, whether the order is an excessive exercise of that power involves the court itself, in a case where there are convention rights involved, itself making the assessment as to whether or not the rights are engaged, what is the appropriate extent to which they would have to be modified to meet other rights, and to each of you about what is the minimum necessary to protect them. That's the way the structure works.
My lord, that's right. That's right. We accept that. And if the court does conclude that the order goes too far, then clearly it's not for the court either to rewrite it or give guidance, but it would need to explain its reasons for so doing, so that the authority could then consider its options and see where it went from there.
Yes,
and the final point about the power to quash, is point 5, is that if any part of the order is quashed, it's not simply a case, of course, of the local authority remaking its decision, like in any other administrative law decision. That's not the way in which the structure of the legislation works. It would have to seek to exercise the statutory power of variation of the extant order under section 61, and it would also be required to undertake prior consultation of that under section 72 1c.
So I'm trying to understand the point you're making now. So we get to a situation where the court says either the thing goes entirely, or it goes in part.
Well, if it goes entirely, it goes. And therefore,
the local authority can then make up its mind whether to have a new order.
And it would have to consult again and follow the entire statutory process once more.
Right.
Yeah. If the court was to quash certain provisions, we'd be left with an order with lesser provisions.
Yes.
If we wanted to add to those provisions,
Yes.
either we could make an entirely new order, but also there is a statutory power to vary under section 61.
I see.
And that's page 4 of the bundle.
You could either have a completely new order. You could revoke the order, could you? Even so far as it remains.
Yes, we could discharge it, yes.
You could discharge the order or vary.
That's right.
Okay, and that's section 61.
Section 61, and if we vary, then we must consult. That's section 72(1)(c).
So you have to consult whichever way you do it.
Yes,
You have to consult.
yes,
Yes.
yes.
Where's the consultation provision?
It's section 72(1)(c), my lord.
You said no. You've got 61.
Yes.
I think we're referring us to 61.
61 is the power to vary.
Do you need to consult for that?
Yes.
Right. That's 72 again.
72(1)(c).
Oh, I see. 71C.
Go to page 9.
Oh, I see.
And in fact, we also have to consult about discharging, which is D.
Okay. Thank you.
So well, those are the 6 points. Now, turning then to the first ground of appeal. This is limited to an issue of statutory interpretation of the first condition, namely the words "those in the locality." And the appellant's case, as we understand it, is that a person in the locality on one or two occasions is incapable of falling within this phrase. If they're wrong on that, their ground of appeal falls, because the judge decided that the second condition was met. That's not an issue. And we'd like to consider first the logical consequence of the appellant's submission, because it is that irrespective of whatever detrimental effect there may be caused to a sole time visitor, irrespective of how many such visitors there may be who suffer the same effect, and irrespective of the probability that you will have the same sole time visitor coming to the locality day in, day out for the next few years, Parliament...
No, I think I think Mr. Davies accepted that if there was somebody, I put him in the case of somebody who came regularly to the same market town, and he
Yes.
said that such a person might well be within the phrase.
Oh, Lord, yes, no, so what I meant is that they have another another cohort of visitors, each coming one time, 15,000 visits to this clinic, and going away. So a large number of people, but only visiting on one occasion each. His submission, the effect of it, is that Parliament is to be taken to have decreed that a local authority simply cannot take action to protect those individuals under what are local provisions. And we say that is a surprising conclusion which the court should come to only if the statutory wording drives it to that conclusion. And we say it does not. Well, maybe then go to section 59. And the section 59 2A contains a number of elements, one of which is quality of life. We say that is a broad and open-textured phrase, and in our skeleton argument we give a dictionary definition of being the general well-being of a person or society, defined in terms of health and happiness rather than wealth. And we say that the quality of life of an individual can be manifested but also detrimentally affected in a myriad of ways. And just as it can be detrimentally affected by a course of conduct continuing over a long period, so too can it be detrimentally affected by one incident which has long-term effect. And then, turning to the phrase itself, those in the locality, again, this is a designedly broad phrase in a statute which also defines public place in a broad way. And we say that at any point in time, those in a locality will be made up of a range of individuals, there for a range of different reasons, with different ties or frequencies of presence. And that all that the statutory definition is getting at is physical presence in a geographical area. Nothing about the phrase itself suggests any limitations, and the Act doesn't prescribe any minimum level of usage. And our very simple submission is that had this been the intention of Parliament in this local statute, then it would have said so. And we do note it has said so in a different context, and that is section 66 and the concept of the interested person. My Lord, you...
Mr. Bowes, forgive me, just before we go to section 66, just looking at 59(2)(a), are you saying that the phrase "those in the locality" has to be interpreted in the context of the earlier use of the word public place as defined in the statute and the breadth of it?
Well, my lady, it will clearly be because you are looking at those in the locality for the purposes of the public place for which the order may be made. That's right.
Thank you. My apologies for interrupting.
No, I'm very grateful, and that perhaps makes the point far better than I did about the wide definition of public place. So, my ladies, we're at section 66, and it's the provision under section 66(1) about those who may apply to the court to question the validity of the order. You see, the draftsman has defined interested person as an individual who lives in the restricted area or who regularly works in or visits that area. So it is obviously designed to limit the class of person who can come to this court, and one can see that is for good reason. It is those who will have the greatest interest in the order that is made, most likely the ones whose behaviour is being regulated. And one sees that it's done so not even by reference to the locality, but by reference to the restricted area, so it's even more narrow. But what we say is that had Parliament similarly intended the phrase "those in the locality" in section 59(2) to be limited in a jurisdictional sense, which is what the appellant's argument is, it would have said so by a same drafting technique, which is a well-known drafting technique, of course, and which was used in section 66. And if we're right on that, this is a complete answer. But can I then make some points?
What's the drafting technique?
To provide an interested person means an individual, to define interested person. And you know, it's the draftsman would have said very simply, those in the locality means an individual who lives in the locality or who regularly works in or visits the locality. Make some submissions about the appellant's counter-construction, if I may. The first is that the basis for their argument, the principal basis, relies upon words not within the statute, not the words "those in the locality," but the rather uncertain concept of being part of or a member of a community. And this, of course, is not the terminology used in section 59(2). Submission doesn't get off the ground. The second point we make about their submission is that it lacks internal consistency and gives rise to uncertainty of application. So far as consistency is concerned, the appellant confidently can say those who live in or work in a locality are part of the local community. But then, as soon as one moves away from that to consider those who visit, it becomes much harder. And my learned friend's submission was that a regular member, I think, to a hospice would become a member of the community. You see, that's a very odd way of speaking. if you have a resident of Ealing whose aged relative is in a hospital in Hammersmith and they religiously visit them every single week, it is a very odd turn of phrase to say that they become a member of the community within which the Hammersmith Hospital is situated. They don't. They visit the locality of the hospital. So not only is it inconsistent, but also it gives rise to uncertainty, because what degree of regularity suffices? Bearing in mind this is an important question in Condition 1, and it's a statute that has to be applied on a day-to-day basis at a local level. And one has to really wonder, did Parliament intend that one was to be mired in unedifying scraps about whether a victim qualified because they were there on 2, 3, 4 or 10 occasions? We say no. The third point is that it in fact results in absurdity. My learned friend gave the example of a fun fair. So let's run with that one. Let's assume that you have a fun fair where there is a gang of youths who are committing antisocial behaviour. Now, on the learned friend's analysis, you can take into account the behaviour towards residents of the locality of the fun fair, those working at the fun fair, and even those who regularly visit the locality, even if they only go to fun fair once. But you can't consider anything that happens to that entire class of person who visit the public place, the fun fair, as a fun fair once or twice and never go back. Well, that simply, we would say, is unrealistic. There can be no possible reason for that limitation. And the consequence of it makes it even more absurd. Because the logic of the appellant's argument that one can only consider detrimental effect to those who are part of the local community for the purpose of subsection 2A must mean, on his argument, that the prohibitions or requirements that can then be made under subsection 5 are equally limited to that class of person, because there are mirror images. One can only make the order insofar as is necessary to deal with the offending behaviour. And so one would have the ludicrous position of a PSPO which directed the youths that they are not permitted to commit antisocial behaviour to those in the public place of the fun fair, brackets, but that does not include people who visit on 1 or 2 occasions only. And if that isn't a friend's submission, he says, oh, well, of course, the order could in fact protect them, then that further demonstrates the artificiality of the interpretation they're putting forward. Well, the fourth and penultimate point is that, standing back a bit, we say that my learned friend's thinking about the local community is a very narrow one, because it appears to suggest that the local community is only concerned about activities which harm those who live there, who work there, or who visit there regularly. We would say that is not how local communities operate. Local communities may well have any number of concerns to ensure that their areas are law-abiding and safe and welcoming to people who visit, whether that be on 1 occasion or 50 occasions. In this case is a good example. A petition of 3,500 people, Sister Supporter, which is a local group, it's not a national group, it's a local group, and in response to the statutory consultation, in excess of 2,000 online responses, 83.6% of whom were Ealing residents, and the vast majority of whom supported the order.
Well, I'm not sure I got the full force of that point. You say if the local community is concerned only with what happens to those who live and work there, it's very unrealistic
Yes.
And then you make a point about the consultation process.
Yes, because it demonstrates that communities, I mean, what he appears to be saying is, well, because the guidance is using the word local community, that's assuming that the only people you are concerned about is those who live there or work there or regularly visit. But these are provisions made to protect and assist local communities. And what we say is that his approach is a very narrow approach to what the members of a local community may be concerned about. They may be concerned about not only their own interests, but also the interests of those who they welcome into their community on one occasion, 20 occasions. And the point I'm making is that the evidence in this case demonstrates that one needs to have a broad response to what the community is concerned about.
Well, have you I totally understand what I would describe as the core of your submissions, which is expressed very, very shortly, which is that the drafter of 59.2a did not seek to qualify the broad terms, those in the locality, whereas that has been done elsewhere,
Yes.
and that therefore indicates that it's not as narrow as the definition elsewhere. Otherwise, you'd have said so. I mean, that's a short point.
Yes.
But that's the heart of the interpretive
Yeah.
approach. The main counter to that, it seems to me, is equally briefly expressed, which is, yes, but if you look at all the commentating guidance, whether it be in the form of the statutory guidance or the statutory memoranda, explanatory memoranda, they don't refer to people who are visitors, but the concentration of the guidance and the explanation given by the Executive or Parliament is directed at those who do live or work in the community. I mean, I'm not sure you actually addressed that particular point by saying, well, they don't matter. Or
No, of course.
I mean, what is your answer to that particular point?
Well, I recognise, of course, that the focus will be on those who live and work in a community, because they are the ones who are going to be experiencing the behaviours every day. But the question is whether those who visit on one occasion are excluded as a matter of jurisdiction.
Well, I'm sorry. So is your answer simply that? Is your answer, which is a perfectly appropriate answer, is well, it's all very well, but at the end of the day, whatever the guidance says, at the end of the day, we have to interpret the words of the statute. Is that the answer?
Well, it is the answer, but also by reference to the points I make about absurdity, about my friend's construction, and also the broad definition of public place.
Right, so we can't take the statutory guidance and the statutory memoranda at their face value. They're not exclusive. They're not an exclusive exposition.
Absolutely not. And as I said, the statutory guidance in itself gives the correct test. It talks about communities and victims. It doesn't run one way. And so far as explanatory memoranda is concerned,
So the point is, so far as the statutory guidance is concerned, you're saying it doesn't just focus on community. It focuses on the concept of the victim.
that's right. And also it does give the correct test within it without any reference to community. And as for the...
So where just take me back to that.
It's tab 5, and it's
Which is the
page
correct
27. It's under purpose.
Which is the correct test?
Tab 5, my lord.
Yes.
It's page 27. It's under the section 2.5, Public Spaces Protection Order, where it has purpose, then test. And also, my lord, of course, the facing page, page 26, where it says the first part of the guidance focuses specifically on putting victims.
Well, I've got that.
Yeah.
I don't think I picked up. You did refer to it.
Yes.
I'm trying to put it in its context. And you're making
My lord,
quite a large number of points.
Yes.
I'm just trying to isolate the ones that are
My lord, yes.
the most important ones.
And my lord, so far as the explanatory notes are concerned,
Yes.
I would simply note that, as is stated in the introduction, they do
Which
not.
page are we looking at now?
It's tab 2, page 12,
Yes.
and
What would
it's.
you draw attention to there?
It's the usual point. They're prepared by the Home Office to assist the reader. They do not form part of the Act, have not been endorsed by Parliament. And so there's no, I mean, it may be that those drafting the notes are using the community as a shorthand, because in many cases, the principal people affected will be the community, using it in that very broad sense. But it doesn't follow from that that is the breadth of the power.
Right. That's fine. That's ground
My Lord, yes.
one.
I then go to ground 2, and that is Article 8. And the appellant's case, as we understand it, is that Article 8 is not engaged because the service users.
That's ground 3.
Well, the way in which I'm terribly sorry. The way in which I'm dealing with it, I'm terribly sorry. Yes, my third submission is dealing with Article 8. I then go on. I'm terribly sorry. I'm doing a slightly different order. I did explain that when I. It seems to be more logical to look at Article 8 first.
So anyway, the next point is Article 8.
Yes, and then I'll go on to
Well, is Article 8 engaged?
my Lord, yes.
Right.
And so, under this ground, we understand the appellant's position is that there was no reasonable expectation of privacy of the service users, and also that, insofar that activities there were not ones of permanent recording or publication.
Yes.
And we say that they're incorrect on that, and the judge was right in his conclusions. Can I take you to two European authorities that are relevant to the issue of Article 8 and abortion services?
Thank you.
The first is in the authorities bundle at tab 19, and it's A against Ireland. Sorry,
Tab 19.
No, it's Liberties Authorities. I'm terribly sorry. It's Liberties Authorities tab. And this concerned 3 women who came to England for their abortions because they were unsure of their entitlement to them in Ireland. And may I take you simply and solely to paragraph 212, which is not paginated in my copy anyway.
Which page number is it? Top right hand corner.
Internal page number is 486.
This is tab 19.
Page 53 of
53.
the report.
Thank you.
I'm sorry, I have a different report, man.
Yes, all right. Right, which paragraph?
And
212.
sorry?
212.
Yes.
212, yes, thank you.
And there is the in its.
Broad concept.
That's right.
Yes. Right to personal autonomy and personal development.
That's right.
Yes.
And it's the first sentence in paragraph 214. While Article 8 cannot accordingly be interpreted as conferring the right to abortion, the court finds the prohibition in Ireland of abortions where sought for reasons of health and of well-being came within the scope of their right to respect for their private lives and accordingly Article 8. I'm terribly sorry, the reference that I have in my notes is not that paragraph. Sorry? Yes. Oh yes. I've gone mad already this morning. I'm terribly sorry. It is 212. It's the last
Is it on
sentence.
psychological integrity as well as decisions both to have and not to have a child
My
or
lady,
come genetic
yes,
parents,
yes.
I suspect is what you
My
want
lady,
us to-
absolutely. That is the paragraph. My note was right, I was wrong. That is the simple point there. And then, staying within Liberty's bundle, may I take you to tab 24, which is the decision of PS and Poland. Oh, hang on. No, it's tab. Well, if I go back to our bundle now and put Liberty's bundle away, because there is duplication. we go back to our authority bundle, tab 13, please. And this concerned a 14-year-old girl who was raped and became pregnant, and she faced extreme difficulties in exercising her right to have an abortion under Polish law, and both she and her mother were applicants. And can I take you first, please, to page 267, paragraph 78, where the violation alleged is summarised. And here both mother and daughter were applicants, and they submit their right to due respect for their private and family life of the first applicant's physical and moral integrity being violated by the absence of a comprehensive legal framework guaranteeing her timely and unhindered access to abortion under the conditions in the applicable laws.
That was a complaint.
That was the claim, my lord. Yes. Then going to page 99, paragraph 27. Page 272, paragraph 99. And it's midway down the page. This is a case where, of course, Poland had guaranteed certain rights to abortion, and it's midway between the hole punches, and it starts in particular.
Yes.
In particular, the state is under a positive obligation to create a procedural framework enabling a pregnant woman to effectively exercise her right of access to lawful abortion.
Yes.
In paragraph 109, the court gives consideration to the position of the mother, because the Polish authorities had denied that her Article 8 rights were engaged. And the court doesn't accept that. In 109, about 8 lines down towards the right-hand side, being however, it cannot be overlooked the interests and life prospects of the mother of the pregnant minor girl were also involved in the decision whether to carry the pregnancy to term or not. Likewise, it can be reasonably expected that the emotional family bond makes it natural for the mother to feel deeply concerned by issues arising out of reproductive dilemmas and choices to be made by the daughter. And then paragraph 111, the court is of the view that effective access to reliable information on the conditions for the availability of lawful abortion and the relevant procedures to be followed is directly relevant to the exercise of personal autonomy, refers to Evans. It says, the nature of the issues involved in a woman's decision to terminate pregnancy or not is such that the time factor is of critical importance. The procedures in place should therefore ensure that such decisions are taken in good time. And then finally, if I may, paragraph 128, the court is looking at the issue of personal data, and this was in the context where the girl's details got out and people came to her room to seek to get her not to have an abortion, and then were outside the clinic when the next day. And what the court says in paragraph 128, just above the second hole punch, starting respecting the confidentiality of health data is crucial not only for protection of a patient's privacy, but also for the maintenance of that person's confidence in the medical profession and in the health service in general. Without such protection, those in need of medical assistance may be deterred from seeking appropriate treatment, thereby endangering their own health. And we would say that confidence in the medical profession and confidence in your ability to access the service with respect for your dignity and privacy is important.
I'm just trying to understand how this fits in with the submissions of the appellants. I mean, the cases you've spoken to us about, showed us here, are concerned with the right of a woman to have access to abortion advice
Yes.
and services, which engage Article 8, and that's a relatively clear position. The point that I think is made primarily here by the appellants is that they're not preventing anybody from that. from those services from having an abortion. All that they're doing in criticism is that they're standing there and they are seeking to persuade people as they go into the clinic
Yes.
that there are other courses of action.
Yes.
I want to understand how you tie these cases in to that case. They say they don't take photographs,
No.
they don't record people's names or anything of that kind, so there's not the equivalent of seeking medical access to medical records.
No.
So, I mean, how, I'm not saying they don't, but that's likely to formulate how these cases impact on the position taken by the appellants, which is really about not preventing people from having access to those services, but simply utilising the opportunity in public to persuade them that there's another course of action.
Well, of course, that turns on the issue of reasonable expectation of privacy, which is the substantive part of my submission. But what I say is that these authorities demonstrate that the state has a positive obligation to provide services. Women have a right to expect services. And if in accessing these, obstacles are placed in their way, then that interferes with the exercise of their rights. And so, yes, it's quite right that there is no case here of confidential information being disclosed or the like. But as I'll be submitting, we do have women who are being sought out and focused upon solely because they are pregnant women having an abortion and subjecting to behaviours which we would say interfere with their respect for privacy. But I'll come on to this substantive submission now, if I may.
Right, I thought you were dealing with substantive submission.
Well, the two European authorities frame the considerations.
Right.
But the essential issue here,
Yes.
because obviously the women are on the highway,
Yes,
they have no choice.
Right.
And so the critical question is whether they have a reasonable expectation of privacy when coming to and going from the clinic. And may I take you to the Supreme Court judgments in Re JR 38, where there's a very valuable exposition of the content of Article 8.
Right, so I want to make sure I'm following this carefully. So, in formulating your point as you've done, do the women have a reasonable expectation of privacy when going to and from the clinic? You're not thereby relying upon any suggestion that what is being done to them might prevent their access.
Well, I am, because...
So that's another point.
Yeah, well, in terms of, because there is clearly evidence that a number of women have cancelled.
So there are 2 points you're making. Let's make sure I get all the
Yes.
points. So one is you say reasonable expectation of privacy.
Yeah.
And the other point you're saying is that the evidence indicates that some women might be put off
Yes,
from going
yes,
to this clinic because of what is taking place.
that's right.
All right.
Or indeed, even if put off, nonetheless delay their treatment. And I've seen that can
Or
have...
delay treatment.
Yes. So may I go then to, in Re JR 38, is Tau 20 of the authorities bundle. And this concerned the photographs of a child being taken whilst they're engaged in a riot, and they were then published. And there was a judicial review claim against the police that publication of that named and shamed the child. And could I take you to paragraph 84 of the judgment of Lord Toulson, with whom Lord Hodge agreed. And in paragraph 84, Lord Toulson refers to the well-known case of von Hanover in Germany, and the point being made between F and G that there is a zone of interaction with others, even in a public context.
So, which paragraph?
It's paragraph 84, and then quoting from,
So the quote.
yes, quoting from von Hanover,
Yes.
and it's just above G. There is therefore a zone of interaction with others, even in a public context, which may fall within the scope of private life. And then in paragraphs 85 through to 85 through to 89, Lord Torson repeats Lord Justice Law's well-known passage from Wood with approval and certain matters from Lord Nichols. So may I ask you, my ladies, to read paragraphs 85 to 88. And then may I also take to paragraph 95, where Lord Torson says the fact that the appellant was a child at the relevant time is not, in my opinion, a reason for departing from the
Which
test.
paragraph?
Paragraph 95. So the fact that the child is not a reason for departing from the reasonable expectation of privacy test is a potentially relevant factor in its application. And then paragraph 98, on midway through, on page 185 of the report, third sentence, third line, the reasonable or legitimate expectation test is an objective test, applied broadly, taking account all the circumstances of the case. See Murray. So what I gain from these is that, per Lord Justice Laws, the central value protected by Article 8 is the personal autonomy of a woman. Her personal autonomy makes her the mistress of all those facts about her own identity, including the zone of interaction between herself and others. And that cluster of values comprising personal autonomy is a defining characteristic of a free society. And that's just from Lord Justice Laws. Obviously there are limitations, and the limitation in place here is that of reasonable expectation of privacy. And in accordance with Lord Nichols' words in MGN that are cited, whether there is a reasonable expectation is a broad test, taking account of all of the circumstances, in particular for the attributes of the claimant, the nature of the activity in which the claimant is involved, the place at which it's happening, and the nature and purpose of the intrusion. So those are, that's there. And it's broad and it's objective. And so in the light of that, and turning to the facts of this case, taking first the attributes of the service users. They are women in the early stages of pregnancy. Some are children. Some are the victims of rape or sexual assault. Some are carrying fetuses with abnormality or fatal fetal abnormality. Some or many, we're talking about early stage of pregnancy, may not have told their friends or family, particularly because they've resolved on a decision to have an abortion. and all have already decided by the time they come to the clinic to have an abortion, exercising a choice over their own bodies. So that is the first element of Lord Nicol's suggestions. The second concerns activity. Well, they are coming to and then going from.
Sorry, the second one is, sorry, just finishing the first one. The second one is
The nature of the activity in which
Nature of the
in which the claimant is involved.
yes.
And that is coming to and then going from a medical clinic to undergo an intimate medical procedure that both in advance and after may give rise not only to...
Sorry, Mr. Bowes, it is important to write this down.
It's-
Now start again.
Well, start under activity.
Yes, yes. So they're coming to and then going from a medical clinic to undergo an intimate medical procedure that both in advance and after may give rise to physical pain and suffering, as well as acute psychological issues and feelings. And their very attendance at this clinic is capable of revealing highly personal information about them. Firstly, that they are pregnant, and secondly, that they are about to have or have just had an abortion. And of course, their activity is coming to access medical care from qualified medical professionals. It is not coming to talk on the highway with third parties about their affairs. Very specific purpose. My Lord, the third consideration is that of place. It is the highway directly leading to the clinic. Service users have no alternative but to come by way of the highway, and because there is no parking, they have no alternative but to access the clinic on foot. And those who choose to come by public transport, one can well imagine that many women seeking this, young women, will not have the finances to afford private transport. They'll come on foot from those public places of transport.
So they come on foot unless they can afford
Yeah.
to be dropped off by a car.
That's right. And even when dropped off by a car, nonetheless, their route into the clinic, even the most direct route, is directly over the very verge where the protesters are. Then the final element in the 4 stages is to consider the nature and purpose of the intrusion. And there are a range of intrusions, we would say. And before explaining them, one needs to bear in mind that they all take place on the highway, by the clinic, in the full view and possibly hearing of all those passing by. And because it is no secret that this is a Mary Stopes clinic, there's a plaque on it, and because there have been demonstrations outside it for in excess of 20 years, those passing by will know precisely what it is, and they will know who the people are and what the conversations are about. And that is what the consultation shows very clearly. Turning then to the range of intrusions, and we would list 12 of them. The first is seeking out and identifying women of reproductive age approaching the clinic. And doing so to identify them as both pregnant women and pregnant women attending for an abortion. The women are, service users are, the direct focus of the protesters. That is why they are there, that is their subject, and we would characterise it, frankly, as directed, non-covert surveillance. The second element is then standing directly outside the clinic entrance with the sole purpose of being in such a physical position so that the service user has no alternative but either to engage with them or to alter their course and go around them so as to access the clinic. The third is direct engagement with the service users by words and deed, and whether or not she wants any engagement. And that is by a range of means, by physical presence at the doorway, by obstruction, by following and talking, and by initiating the conversations. That is, as we say, that is their very purpose. The fourth issue is then engaging directly with the individual service user about the choice she has made and ultimately seeking to encourage her to change her mind, to tell her that there are other ways. And the evidence discloses, of course, in a number of cases, telling the women that what they're doing is wrong or morally wrong. The fifth point is the giving of literature. We have in the bundle 2 leaflets. Their originals are coloured pink or blue. I don't take my ladies to them, but I think my ladies will have read them. The pink one is addressed to mum and says it's not too late to save the life of baby. The blue one sets out in bullet form point possible physical and psychological complications, including breast cancer, alcohol and drug abuse, and damage to maternal instinct.
Could you just remind us of the reference?
It's a supplementary bundle, tab 2, page 6 for the pink leaflet and page 2 for the blue leaflet. The colours are self-evidently chosen to reinforce a girl-boy-child stereotype, as is the giving out of blue and pink rosary beads. The sixth intrusion, we would say, is the displaying of photographs on the ground of embryos at different periods of gestation. Just again, for my lady's note, it's supplemental bundle, tab 10, page 199. Can only be designed to try to unsettle a woman about her choice. and indeed, and in parentheses, the court will note from the Cabinet report that when it discussed the activities of the pro-choice protesters to see if there was ground for accommodation, there were three absolute no-goes. One was standing at the clinic, the other was engaging with women, and the other was putting out all of these photographs, which they described as their key tactic. The seventh element is praying, whether audibly or not, for what the protesters believe, and I of course accept, have absolute moral beliefs, are the souls of the fetuses that are being aborted in the clinic and are to be aborted by the particular service user that they are speaking to. Whether intended to or not, this inevitably provokes anguish and feelings of guilt. And yesterday I took the court to one such statement of client E. They started praying, she went in, she felt even worse, Catholic guilt. The eighth element is the conducting of group vigils. Again, drawing further public attention to each service user as she comes and goes. Again, whether intended or not, perceiving that she is being watched and she is being judged. Again, the words shame and guilt come up repeatedly. The ninth element concerns conversations when the service user leaves the clinic, ordinarily having had the treatment. And I took the court to the evidence yesterday. One recalls the photographs of the gentleman speaking to the service user about maybe if she changes her lifestyle, she should have kept her baby. And if you pray, you won't end up back here, Mum. And even the witness statement of Ms. Yamut, the local authority employee, who was told, if you pray, my dear, you will not come again.
Which is the reference?
That is, the first reference is supplementary bundle, page 172, and the second one is 194, paragraph 7. The 10th element is the leaflet that is then given when the woman leaves the clinic. I won't take you to it, but again, the page reference is supplementary bundle, tab 2, page 9, and that leaflet talks about offering counselling for those who regret the abortion, a weekend retreat for those who are suffering after abortion, and then a photocopied quote from Pope John Paul II, which says, inter alia, certainly what happened was and remains terribly wrong. The 11th issue is taking or pretending to take photographs of service users. And one notes that in the responses to consultation, that's supplementary bundle, page 131, figure 2, some 22.8% of respondees said they had witnessed that behaviour. And there is also evidence, supplementary bundle, page 63, of protesters pretending to take photographs. Of course, it doesn't matter if photographs are taken or not. It is the perception. And the final element is the further drawing attention to the service users which occurs when CIST supporter are present and they are conducting their counter demonstration, equally an exercise of their Article 10 and 11 rights. We've seen the photograph, ladies will have seen the photographs. It's almost like a demo. So, ladies, we say that applying this test in a broad way, objectively, taking account of all the circumstances, the service users to this clinic undoubtedly have a reasonable expectation of privacy when attending. That's all I wish to say about that part of the submission. In the respondent's notice, we also say that the articulate rights of other visitors to the clinic and members of staff are engaged.
I thought you had a second point, which is that's the expectation of privacy.
Yes,
If then I put to you, you didn't accept. That's another element of this.
yes, that's
Is putting people off
that's right.
because of what's happening.
That's right. And the evidence of cancellations. That's right.
I mean, do you want to? All of those 12 submissions were aimed at the privacy point.
Yes. Oh, sorry. I'd already made. It's a short submission. The additional point is the fact that the activities give rise to the risk of women not exercising their right to go to this clinic timeously to have an abortion.
Is there any particular evidence you want to refer to on that?
I can give my lord the reference to in the Mary Stopes bundle. There is evidence of that. May I give you the? May I just check the note and give it to you during the course of the morning? But yes, we have that. I think. So, ladies.
What happens? In fact, what happens in relation to the issue of non-acceptance of this evidence by the appellant? I mean, they said they don't accept all this evidence.
Well, it doesn't. Well,
We have to form a view about that. It would be very difficult for this court to do that.
no, I think that the court is entitled to say, well, this was the evidence before the authority, which it accepted. If the evidence does not have any degree of cogency whatsoever, then the court might think twice. But what strikes one from the evidence obtained for a number of different sources, direct witness statements, statements from the statutory consultation, and from residents, etc., is there is a striking similarity in the experiences of service users, local residents, employees, and those engaging in other activities in the locality about what is happening. And the fact that one does have the photographic evidence with the transcript of that gentleman in July 2017, which is a standard GCN day, which is not put in issue, speaks, we would say, volumes.
What's the reference to that?
That's the reference at it's pages. It's the sister supporter photographs, which I think are page 196 to 172 to 176. I mean, I should. There was also evidence before the judge in relation to the cancellation point that from Mr. O'Brien, this is page 311 of the supplementary bundle, that 311, paragraph 20, that following the order being made, the biggest change was that the DNA did not attend rate has dropped.
That's your witness statement, isn't it?
That's Mr. O'Brien's witness statement, that's right. Wasn't before the respondent decision maker, because obviously it's what happened after the order was made, but it was before the judge.
What was before the decision maker? Is the Mary Stopes response, page 54? And this is of significance in a time-sensitive procedure.
My lady, absolutely, because as my lady well knows, any day or week can be critical depending upon the form of treatment one woman can have, and also depending upon the reason for the abortion. Those are my submissions on engagement of the service users articulate
Can I
rights.
just ask one thing? We heard from Mr. Havers in broad terms that they don't accept the evidence.
Yes.
Is the basis of that, or was the basis before the judge on this that the witnesses were lying, or that it wasn't their group that was responsible for these behaviours, or exaggeration, or I don't think I've quite grasped in what respect they don't accept the evidence. I know they don't, but I haven't quite grasped.
Well, we're not quite sure either. I mean, we think it's encapsulated in their view that it all comes, it doesn't amount to much.
I see.
They follow their specific ground, which is no detrimental effect, which they actually scale argument in the High Court.
Yes, I think I'm told that the skeleton argument in the High Court effectively made that point. I don't have the page reference for you, but
Which skeleton argument?
the appellant skeleton argument in the High Court. In fact, I think you'll find it.
So it's not so much that they undermine the actual facts. What they say is that even looking at all of that, really, they don't accept the premise that this amounts to a serious intrusion or.
I think that's right. I mean, I think
situation.
I think that's right. I think that there is also certainly the fact that the appellants who are part of the GCN, they would say that, for example, the Friday group who stand outside with the photographs, they're not associated with them, and those kinds of points. But you know, that's the difficulty here, that we don't have one group doing the activities; it's a number.
Thank you very much.
Did the judge reach a conclusion on the question of cancellation? I've got a vague recollection he did. Did the judge say something about cancellations?
I'm not sure he did. I don't think he did.
Did he say anything? What did he say about the evidence on this?
He dealt with the evidence in.
I think it starts at 122, doesn't it?
My lady, it does. That's right. It deals with it in paragraphs 44 under the element of evidence of detrimental effect.
His paragraph 4.
And then the.
One moment, let me just catch up. Right, he sets out the evidence.
Yes.
Yes, what does he then say?
Well, then, if one goes to paragraph 54, he records what the claimant's case was. With few exceptions, the activities of those outside the clinic were innocuous.
So where are you reading from now?
Paragraph 54,
54.
first sentence. And it's right that he does, in paragraph 46, caution himself about the evidence in the consultation. Because as he records in paragraph 46, the views expressed in many cases were likely to be determined entirely, almost entirely, with reference to the moral position of those responding on the issue of abortion, rather than the broader aspects. And he refers in particular to the "Be Here For Me" responses, which were the responses sent on behalf of those objecting to the making of the order.
At paragraph 51, taking up my lady's point as to the nature of the non-acceptance of the evidence, in a couple of sentences, the judge identifies some of the objections taken.
Yes.
Am I right in thinking that whilst they characterised what was happening as innocuous, they didn't, however, challenge detrimental effect?
No, they did.
They did.
They did. I think that I should say that I think that there is detailed section in the skeleton argument in the court below.
Tab 12.
Does
Tab-
it,
Tab 12.
does it, I'm trying to tie this down to something concrete. Does it come to this, that the judge accepted that the local authority had the power to make an order, that was his conclusion in paragraph 55, because, taking the evidence as a whole, he found that the statutory requirements were fulfilled, namely that those in the locality, which he described as including the visitors here, namely the people visiting the clinic, had had their quality of life affected.
My lord, that's right.
I mean, is that that may be sufficient for you?
I think that's right. And equally, paragraph 54, fourth line from the bottom, he refers to there being a considerable tranche of evidence and information before the defendant of activities which many would reasonably consider to be fully capable of having a detrimental effect.
Although he says, look, you've got to be careful. We've got to be careful about all this evidence. Some, is second-hand.
Yes.
Sometimes some dates from some previous time. Nonetheless, the statutory requirements were fulfilled. Namely, these people, the service users, who were the visitors, who were people in the locality,
Yes.
had had their quality of life affected.
That's right.
And therefore, you say that is a sufficient assessment of the evidence of the interference and so on.
That is right. Yes.
Right. There are a couple of places at the back of the court if you want to move there. Or at least one. There's one there. Sharon, are there any more seats anywhere? And there's a seat here. There's one seat here. There's one that side. Okay, thank you. That deals with the evidential part.
Well, that is our submission on the engagement of the service users' Article 8 rights. In our respondent's notice, we do raise the Article 8 rights of visitors, alternatively members of staff. I recognise that if we are wrong on the Article 8 rights of service users, then necessarily we are going to be wrong on these additional categories. Whereas if we are right on the Article 8 rights of service users, then whether or not the Article 8 rights of staff or other visitors are engaged probably doesn't make a great deal of difference in the overall balancing analysis.
So if you're wrong with service users, you won't get anywhere with the staff.
Yeah.
If you're right on the service users, you don't need anything
Yes.
on this point.
Yeah. So we have our written submissions in our skeleton argument, but I won't address it.
Thank you very much.
That brings me then to the next ground of appeal, which is ground 2, which I'm taking out of turn, and that is the ground that the judge erred in his consideration of proportionality. Now, I think we are entitled to say, as a little complaint, although it will take us nowhere, that ground 2 as pleaded has nothing to do with the judge's approach to proportionality. It was all about his approach to the issue of the statutory conditions being met. Their focus was on paragraphs 51 to 55 of his judgment. It is only when we raised to assist the court the judge's conclusions in paragraph 97 in our skeleton argument that back came a supplemental argument saying, yes, this is what we mean. What we're saying is that it was a matter for him to determine proportionality for himself, and he didn't do it. See paragraph 97. So their ground has changed, and we say that the way in which they read paragraph 97 is the way that we would respectfully ask the courts to read it. And in fairness to the judge, because of the very careful judgment he made, I'd like to just take you through this submission briefly, if I may. The starting point is the judge's judgment of paragraph 25. On page 118, where he sets out a long passage from Lord Justice Beatson's judgment in A's case, which itself refers to Denby and misbehaving and Huang. And paragraph 37 of Lord Justice Beatson's judgment sets out that the matter in terms of compatibility is for the court. He then goes on in...
Where are you referring to there?
It's paragraph 37 of Lord Justice Beatson. It's midway down. In the last
It is the court must decide that point.
Yes, that's right. He then refers to the structured proportionality test that feeds into that from De Smith in paragraph 26. And in paragraph 27 says, I'm satisfied that such an approach is consistent with the decisions of the most recent authorities on the point. And then he also notes in parentheses Lord Sumption's comments in Bank Mellat, which again is another exposition of the court's responsibility for undertaking structured proportionality. The judge then goes on in paragraphs 44 to 55 to consider the issue of detrimental effect, and he holds that the authority was entitled to conclude as it did, and then he considered convention interference from paragraphs 56 onwards. So firstly, he considered the question of Article 8 engagement, and it is clear from the way in which he dealt with it in paragraph 61 that he fully understood that it was a matter for him to be satisfied that the rights were engaged, and we see that in paragraph 62 and 63. He then goes on to consider Articles 9, 10, 11 and 14, and he does so by reference to the very full consideration given to those matters in the Murphy report. And we would say there's nothing wrong in that. This is a case where certainly we would suggest that the consideration given by the authority itself to convention issues is a far greater consideration than many courts would see of other public authorities given. He then, at paragraph 68, assumes, for the sake of argument, that Article 9 is engaged.
Which paragraph?
It's paragraph 68. So again, he is assuming for himself that Article 9 is engaged, and although some criticism is made about the extent to which he did it, it may have been a bit grudging. I mean, it's quite common for courts, if in doubt, to assume in someone's favour, and there's nothing wrong here. Article 9 is, of course, a difficult right to determine what the manifestation is, and we'll look at that in due course. He then, at paragraph 72, in terms of the balance, recognises that where you have competing rights, it's not a question of one right intrinsically having a greater worth, because he quotes from Kudirk, the last sentence of which in paragraph 72 says, indeed, as a matter of principle, these rights deserve equal respect. That's Articles 8 and 10. So again, he's undertaking the analysis himself. Paragraph 74, he concludes for himself that the protection of the rights to privacy of the users of the centre was a legitimate aim, i.e. not undertaking a review of the authority's decision. And then, similarly so, in paragraphs 75 and 76, paragraph 75 says the next stage of the review requires the court to consider whether the measures employed are capable of achieving it. And concludes in paragraph 76, last sentence, there is therefore a rational connection. Then one comes to the terms of the PSPA, which again he looks at for himself. And then paragraph 90 onwards cites from the court's decision in Annan, which I will also take my ladies to, which is an important case, because it's a case where the court was balancing competing convention rights, Articles 8 and 10. And then finally we come to, after all this very long references to Van Annen and distinguishing it from Van den Dunnen, comes to paragraph 97. And here he says, in the circumstances, I do not doubt there has been a significant interference. So again, he's looking for himself. The sentence which is the difficult sentence is the one beginning, nevertheless. He says, nevertheless, I am satisfied that the defendant was entitled to conclude on the totality of the evidence information available to it that the making of this PSPO was a necessary step in a democratic society and
Further down, I'm also satisfied.
That's right, yes.
Including the effect of the activities of the protesters would like to make such activities.
Well, that's right. So these are the two passages. These are ones which we ourselves highlighted. It clearly could have been phrased better. But what we say is that if one reads through the judgment and sees the care that the judge has taken in setting out the test correctly, following it step by step by step, it should be slow to conclude that at this last step the judge actually went wrong in law. And we would say that his detailed citation from the Murphy report reflects no more than the fact that he recognised that that report had given very detailed consideration to the issues, which was sufficient for his purposes in this case. So that's how I put that submission.
Yes.
If I'm wrong, it falls to my ladies to do that, to undertake that assessment. And can I just make one point about the additional bundle of documents that we filed, just to explain the position with that. We filed an application notice in June for permission to rely upon additional evidence. And this was largely because of what we perceived to be ground two, that is a merits-based approach for the justification of the PSPO itself, as in the Section 59 tests. That application was directed to be heard along with this appeal and was listed, and we provided a bundle of additional documents last week to the appellant, and I hope that members of the court also received that. That bundle solely contains documents that were exhibited to Mr. Murphy's witness statement before the High Court, all of which were before the judge physically, save for the entire tranche of 159 responses to the BPAS back-off campaign. He was provided only with a few to try and keep papers manageable, but they were available to him. And that bundle contains all of that material, the full consultation responses from Mary Stopes and BPAS, the full consultation responses from statutory bodies and other local churches, and the minutes of the meetings with the interested groups to see if we could figure it. And our view was that although the appellant then clarified that they were not in fact saying it's a full merits review, because this court might well have to undertake the proportionality assessment itself, it should at least have available to it the same material that was available to the judge and to the local authority decision maker. But we held fire to see how the appellant put their case on proportionality, to see whether there was any need to trouble the court with a large bundle of papers. We don't think we need to, because in his submissions, my learned friend barely touched upon the body of evidence in the supplemental bundle evidencing the imputed behaviours. In fact, not a single page, save for one paragraph from Mr. Murphy's report giving a bullet point summary. There was no specific criticism of the evidence, and there is no submission, as we understand it, that there was no insufficient evidence before the appellant permitting it to make this order in these terms. Now, if that is right, and given the way in which they put their case in proportionality, we don't think we need refer the court to any other materials. Our view is that the evidential materials in the supplemental bundle are ample for the court itself to assess proportionality. Of course, the court will bear in mind, as I know it will, that as these reports make clear, sitting behind them, and the quotes that are put within them, there is a number of other documents giving the original complaints or original statements, which the court doesn't have, but the judge did. So it's a long-winded way of saying we don't want to rely upon that for explaining why. Can I move then to the actual...
So we don't have all the material before
No.
us, before the judge and decision maker.
That's right.
We have all except a few.
No, you're missing quite a lot. Yeah.
We haven't got source material that backs up the analysis in the Murphy report and the quotes that we find in the Murphy report.
That's right, yeah. The quotes in the Murphy report, in the Mary-Stopes report, and the BPAS report are all representative quotes from the source material. And the court doesn't have, in fact, nor did the judge, the some 1,500 pages of original comments from the statutory consultation, which I haven't read either. But we say that there is clearly enough material here. If that point is taken issue with in my friend's reply, then we may have to revisit it, but for the moment, we don't want to trouble the court with anything else. So then, going to the issue, the balancing issue, and the first point to make is that...
What do you want to say? Don't you want logically to deal with Article 9?
Well, I'm going to deal firstly with the point about how the approach generally to the rights, because there are competing rights here, then Articles 10 and 11, then Article 9.
Right. But don't, fine. You follow your own course.
Yep. Because I think I detected a sense in Malone Friend's submissions yesterday, and I may be wrong, that maybe in a sense saying that where Article 10 and 11 is engaged, they are in some sense intrinsically stronger than Article 8.
Well, I don't think he exactly said that. I think he said that if he didn't succeed on 10 and 11, he wouldn't succeed on 9, as it were. I mean, because 10 and 11 are strong enough on their own.
Yes.
He did say it goes into the mix.
No, I accept it goes into the mix, but it's. I just want to make sure that make the point that Article 8 is as important as is Article 10 or 9 or 11.
Anyway, from your, is there a big point about Article 9? So far as you're concerned, you accept below that Article 9 is engaged.
Well, I can deal with Article 9 now if you wish.
Well, it seems to me sensible when it comes to talk about proportionality, know what it is you're talking about.
Well, I was going to do that, but I was going to do Article 9 after Articles 10 and 11, but I can do it now. My Lord, Article 9, as my Lord says, I mean, the first point is that the Cabinet report referenced the views of some of the activists, and that some of the representative groups took the view their activities were part of their religious manifestation.
Yes.
And both the respondent and the judge proceeded on that basis.
Yes.
Our position on a proportionality assessment, both generally and in terms of the order, is it doesn't matter to us, to our position, whether Article 9 is engaged for all or some of the activities. And we say that Article 9 actually doesn't add very much, if anything, to Articles 10 or 11. But because it falls to the court to undertake this acute consideration of the competing rights and what they consist of, then the court may need to consider for itself which of the activities undertaken by the protesters are in fact a manifestation of their Article 9 rights and which are not. And we submit that the approach should be as follows. Firstly, that where the manifestation does not take a generally recognised form, such as prayer, there must be a sufficiently close and direct nexus.
Are you saying prayer isn't a manifestation of religion?
No. Where it is not a generally recognised form, prayer being a recognised form, there must be a sufficiently close and direct nexus between the act and the underlying belief.
There must be a sufficient nexus, yes, between...
The act and the underlying belief.
Yes.
Secondly, that one way of answering that is by asking what the primary purpose of the activity is. And thirdly, that, unsurprisingly, it is a question of fact in every case. And to make good those points, may I take you first to Van den Dungen, which is the authorities bundle at tab 6.
Yes.
And if I could take my ladies to page 44. And the court's already been referred to.
Right, let's go on page 44.
44 is vantage.
Sorry?
44 is vantage.
End of
Oh,
page
sorry.
41.
Page 37 is Van den Dungen. And on page 39, in the second paragraph, there is the reference to the Convention not always protecting all manifestations. And the next paragraph says this: the Commission notes that the applicant's activities were primarily aimed at persuading women not to have an abortion. The Commission considers that the activities at issue do not constitute the expression of a belief within the meaning of Article 9, and therefore finds it manifestly ill-founded. So it appears here that the basis for not finding the activities in the clinic to be protected by Article 9 was a primary purpose test. Now, my lord, ladies, we cannot find any other reference to Van den Dungen save for the ones referred to by my learned friend. We can't find any reference to a primary purpose test either. But there it is. This is what this authority says. The authority in which it is referred is Van Schiedel, which is the next tab. That's page 42. And that again is an admissibility decision. And this was a case, as one sees on the foot of page 42, where the applicants entered an abortion clinic and proceeded to pray on their knees in the clinic. They were asked to leave and didn't do so, and they were convicted of a breach of the peace. And the holding of the Commission is on page 44. And in the third paragraph, the second sentence refers to case 2283893. That is Van den Dungen.
Yes.
It then goes on to note the applicants sought to manifest their religious convictions by a communal praying session. But it says, insofar as applicants' activities at issue can be regarded as expression of belief, they were justified by the interests of others. So even here it appears that the Commission wasn't going so far as to say that the act of praying in the clinic did in fact engage Article 9. So the use of the word insofar as. So there we are. And the only other case that has already been taken to, that's a Weeder. That builds upon the first point in Van den Dungen about the manifestation being the sufficiently close and direct nexus. So in the light of that, and looking at the activities here, the principal activities, and so far as engagement with women, seeking to get them to change their mind, we would say that this falls on the wrong side of the line in terms of engagement with Article 9. The primary purpose being of that to seek to get women not to have the abortion. And similarly so in relation to the handing out of leaflets and the displaying signs of fetuses. We would say that none meet the test for Article 9 engagement.
Those three specific examples.
Yes, yes. And then the harder one, which we entirely accept, is the act of where GCN have someone at the door and have two people praying, whether that engages Article 9, which raises difficult issues because prayer in itself is a manifestation. But it may be thought that prayer here is not prayer in and of itself, but it's prayer to support the activities of those who are engaging with the women. And so harder issues arise. But, my lord.
What's your submission?
Well, we say it falls the wrong side of the line.
You say even prayer?
In that context. Because it's...
I thought you'd accepted that Article 9 was engaged here.
My lord,
But you seem to be saying that nothing they're doing, including prayer, engages Article 9.
No, my lord, we accepted that Article 9 is engaged, but I'm trying to assist, because the court has to make that assessment for itself.
Both councils say they agree Article 9 is engaged. I mean, it's hardly likely that the court's going to say, well, it isn't.
Well, no, it's engaged, certainly, obviously the praying is clearly engaged. All I'm pointing out is that if one is looking at the authorities and trying to analyse what is happening here, and if Van den Duggan is correct as an authority, then some of the activities fall on the wrong side of the line.
Well, which activity falls on the right side of the line?
The general prayer, the prayer vigils.
The prayer vigils do fall on the right side.
Yeah, but those are the vigils, the Saturday morning ones.
Oh, I see.
Yeah.
So you make a distinction between the Saturday morning vigils and other prayers.
My lord, yes. But as I say, for the purposes of our submission, it doesn't make a difference.
Yes.
May I then now go back now, or rather go onwards to the balancing issue?
Yes.
And the first point to make is that, as has been confirmed at the highest authority, Article 8 is as important a right as is Article 10. And I don't need to give my ladies the reference for that. And there's also authority that where the values of competing rights are in conflict, then the court must focus intensely on the comparative right of the comparative importance of the particular rights being claimed. That's fact specific.
Comparative importance of the particular rights on the facts.
That's right. Then take into account the justifications for interfering with or restricting those rights, and then applying the proportionality test to each. And it has been said, of course, as akin to an exercise of discretion. And just for my lady's note, that is from Murray, Authorities Bundle, tab 12, page 236, paragraphs 24.
Well, what is the discretion point?
That in effect, it's akin to a discretion because one is balancing the competing rights. And similarly, if I can give you another reference where the proper approach was set out by the Supreme Court by Lord Mance, that's PJS and News Group, that's Authorities Bundle, tab 19, paragraph 20, where again the proper approach was set out. I would like to take you to Annan and Germany, because it is a decision relied upon by the judge, and it is an example where the European Court itself has had to balance competing rights in the context of Articles 8 and 10, as opposed to Article 10 arising when the justifications put forward by the state have been other things, such as traffic difficulties and disruption to ordinary life. That's at tab 16 of the authorities bundle. My friend took you to parts of it, but not, we would say, all the necessary parts the court to understand what Annan was deciding.
Just so we can understand where you're going, the direction of travel here. Mr. Havers' submission was that in carrying out the balancing exercise, his primary position was that effectively in this case, on the facts, Article 9 and 10 rights should basically, I don't like to use the word trump, but
Yep.
they should overwhelm
Yep.
the Article 8 rights entirely, so that actually at the end of the day, the Article 8 rights don't need to be preserved at all. And if he's wrong on that, do you get to a question where exactly what is the
Yeah.
form of the order, and is the order
Yes.
a proper recognition of what is the least that could be done to maintain the two
Yes.
rights? Are you addressing, now your position is exactly the opposite as I understand
Yes.
it. You're saying that the Article 8 rights are so powerful that
Yes.
they could be overwhelm the rights
Yes.
of Article 10 in
Yes.
9 and 10. And then presumably you go on and say, but if that's wrong, then you go on to do this analysis of each of the provisions in the order.
My lord, that's right. Yes.
So at the moment, are you addressing the point that here the Article 8 rights overwhelm everything under Article 10 and Article 11? Is that what you're dealing with?
I am, yes.
Right.
And before I come to that, I'm going to look at how the European Court in Annan reasoned where one had competing fundamental rights, then to address in brief whether what the protesters were doing was in fact contributing to a highly controversial debate of public interest, which may get special protection, and we say it wasn't, and then go on to say why, in the balance, Article 8 wins out for a number of reasons. So Annan is at tab 16, and the campaigner was a campaigner against abortion, as we know, and we see from paragraph 7 on page 384 that his campaign was distributing leaflets in the immediate vicinity and depositing leaflets in all letterboxes. There's no suggestion there of any, well, there's no evidence of any particular activities towards service using. And we see what the leaflets say in paragraphs 8 to 10. And this was, we would say, clearly a political and educational campaign directed towards local residents and businesses, bringing information to their attention about what was going on. The doctor's paragraph 13 obtains an injunction on the grounds that the leaflet created the erroneous impression that what they were doing was contrary to law. If one goes, please, to paragraph 54, where the court considers what competing convention rights there are, and it settles in paragraph 54 upon the doctor's right to protection of reputation. So that was the extent of their Article 8 right engaged here. There is evidence that the clinic later closed. We see that in paragraph 62, but there was no evidence that that closure was caused by or contributed to by the leafleting. That's the second half of paragraph 62. So that wasn't the basis for the engagement of the Article 8 rights. Going back to paragraph 52, the court sets out the well-known general principles, and then at paragraph 53 says, another principle that is consistently emphasised in the court's case law is there is little scope under Article 10 for restrictions on political expressions or a matter on debate of public interest. It then goes on at paragraph 56 to note that in cases such as the present one, the court considers the outcome of the application should not in principle vary according to whether it has been lodged with the court under Article 10 by the person who made the statement in dispute or under Article 8 by the person who was the subject of that statement. Indeed, as a matter of principle, these rights deserve equal respect. And again, we find that in domestic jurisprudence. So far as the court's reasoning is concerned, paragraph 58 notes that the domestic court expressly acknowledged that the applicant's statement in the leaflet addressed questions of public interest and that he was allowed to pursue his political aims even by the use of exaggerated and polemic criticism.
I'm sorry, I was writing something down.
Sorry, madam. It's the paragraph 58,
58, so far.
and it's what the court had recognised. Then paragraphs 60 to 61, the court notes that the statements in the leaflets about the abortions being unlawful was in fact technically correct as a matter of German domestic law. We see that from the last paragraph of 60. And it then goes on to say that although the layout was designed to draw your attention to the headline sentence, anyone reading it would understand it properly in context. So when one comes to paragraph 62, one notes from 6 lines down, the court also points out the applicant's campaign contributed to a highly controversial debate of public interest. And when one comes to its conclusions, one sees how important that conclusion was in the balance. Says 64, having regard to the foregoing considerations, and in particular the fact the applicant's statement, which was at least not in contradiction with the legal right with regard to abortion in Germany, contributed to a highly controversial debate of public interest, the court, in view of the special degree of protection afforded to expressions of opinion which were made in the court's debate on matters of public interest, finds that the fair balance should have been struck in the activist's favour. So Annan is a good example where the European Court has focused carefully on the content of the particular Article 8 right engaged and the particular Article 10 right engaged, and has determined which one should take precedence. And what took precedence there, we would submit, is firstly because the doctor's Article 8 rights was a right to their reputation, and there's no great evidence that, or no evidence at all, that their reputation had suffered, set against the claimants' Article 10 rights, which they found contributed to a highly controversial debate of public interest. And we submit that this case is very different, and the balance is very different. Firstly, and I'll submit it in due course, because you are concerned with very different Article 8 rights, and secondly, because we do not accept that the impugned activities contributed to a debate of public interest. They were designedly aimed at the individual service users and them alone to get them to change their minds. I turn then to the Article 10 and 11 rights engaged here. And can I say that we accept the propositions from the European Court cases cited by Liberty in their skeleton at paragraph 18. They are well-known principles, and we accept what they there say. But we would respectfully point out that in none of those cases was the court balancing the applicant's undoubted Article 10 and 11 rights against equally fundamental convention rights. They were all cases where the public authorities had restricted people's freedom of expression or freedom of assembly for other general rights about, civil disturbance, ordinary, day-to-day inconvenience and the like. So ours is a very different case. So when we turn to the Article 10-11 rights of the pro-life groups, and clearly focusing on the applicant and the activities undertaken by the Good Counsel Network, we submit that the reason for their attendance and assembling is not an expression of opinion which is made in the course of a debate on a matter of public interest, which per annum has a special degree of protection, but as I've just said, they are coming here simply to canvass their views with individual service users. They are not contributing to any wider public debate. And in support of that, I'd make the following points, if I may. Firstly, it is no part of protests here to hand out leaflets to members of the public about the wrongs of abortion, either morally or legally. The only leaflets that are produced are for the service users. They are the audience. And indeed, one notes from the applicant's witness evidence, just give you the reference, it's Supplementary Bundle, tab 23, page 339, paragraphs 5 to 8. One of the applicants complains that since they've been moved to the designated area, it's difficult to tell if people are approaching the centre as they pass by. I don't want to hand out leaflets to people unnecessarily. So, it shows it's focused. The second point is that the Good Counsel Network defines their mission as offering practical help and support to pregnant women and post-abortive women. The reference to that is in the Cabinet Report, Supplementary Bundle, page 92, paragraph 4.2.2. It does not describe itself as a campaigning group, nor a public campaign.
Not describe itself as a
Campaigning group, nor a public campaign. The third point, as I've already mentioned, is that the Good Counsel Network told the respondent they were unwilling to consider a change to their core practices, their key tactics, which were approaching women, standing at the gate, having displays of fetuses. That is why they're there.
We're focusing very much here on this particular group, but of course there is also pro-life, there are pro-choice groups, and the order is designed to deal with them.
I will come to the pro-choice groups, absolutely, because their position is slightly different. I will come to them, of course. Yeah, but I'm focusing on whether this group's activities are contributing to a matter of public debate. And the other couple of points to note is that there is no evidence of attendance by any pro-life protesters on a Sunday when the clinic is closed and there are no clients coming to and from. And it has also been noted in the evidence that on a surgical day...
How far does that take you? I mean, if people want to protest, for example, about the fur trade, and there's a fur shop that opens during the week, it closes on a Sunday, the fact that they don't protest on a Sunday wouldn't necessarily indicate that they're not protesting against the fur trade.
It's a minor point, but it goes into the balance. It goes as part of of our submission that this is not the primary purpose here. And so we say, in summary, that the true nature of this protest.
Sorry, was there another one? That was 4. Was there another one in addition to that? I thought you said there were another 2 points.
I suppose the other point to make is that on surgical days, client staff have noticed that the protesters stay for longer because there are more people coming to and fro to engage with.
Do you want to refer us to evidence on that?
Yes, it's supplementary bundle, page 187, paragraph 4 of the witness statement. And so we say in summary that the true nature of their protest is directed at the individual women and makes a very limited contribution, if at all, to the wider debate on abortion.
How does this Saturday vigil fit into that?
Well, that is still part and parcel of people at the gate.
That's a large group of.
It is a larger group. That's
people
right.
praying.
That's right.
But is there any evidence that is solely there to target individual people?
I don't believe there is, but it takes place at the same time as the counselling at the by the entrance to the gate.
So that vigil might be evidence of a wider statement of views.
That is and can be the high point of the case against me on that issue. So that is the pro-life activists. Turning then to the pro-choice activists.
Yes.
Now, it would appear to us that their protests are more designed to contribute to public debate because their focus is upon a woman's right to choose, and they are there seeking, as they see it, to assist that woman in exercising their choice. But they're necessarily right. But then the final point to consider under Articles 10 and 11 is this very point, that you do have 2 different groups, each exercising their own convention rights in direct conflict with one another. And clearly they can do that. That is the essence of a healthy democracy. And if one has, for example in Hyde Park, loud, noisy demonstrations, that is fine. The difficulty that we have here is that their exercise of their competing rights further impacts upon the exercise of the service users' Article 8 rights. Because like it or not, by Sister Supporter being there, and there being 7 or 8 people in pink jackets, 20 people singing, that further demonstrates and shows and singles out the service users as women coming to an abortion, in effect running the gauntlet. And we say that is a factor which the court should take into account in determining where the ultimate balance lies. Because it's not the service users' fault they've got competing groups there. Sure, what they would simply like is peace and quiet and respect and privacy. But this is the reality, and night follows day. If this order is set aside or if it's changed in material ways, then come next week you will have competing groups back there. And the service users will again have to run the gauntlet. And that is something that does feed into the balance.
Right, let me put it in my A language to make sure I can deconstruction of that. You're saying the pro-choice groups who may be making a more general statement, not aimed at the particular people who are seeking to use the clinic. The only reason that they're there is because the claimants in their group are there. If the position is that the claimants ought not to be there because, as between them and the women using the clinic, the Article 8 rights should trump it because they're not making a contribution to the general debate, but just aiming at the women, then that decision, that balance should not be affected by the fact that the pro choice are there, because that's consequential Is that, I mean, I'm
Well,
afraid-
that's the first point of it.
Right.
But also, one has to bear in mind the interference with the Article 8 rights of the service users are exacerbated by the fact that one does have protest and counter-protest. And so when you're balancing
It's
all...
noisier, it's more likely to attract press attention.
Yeah.
And all the rest of it.
Well, it's you've got 20 or 30 people outside, all there because you're going in. It's inevitable.
So you're saying the Article 8 rights are prejudiced, are increasing, the prejudice to them is increased by the fact that the
Yes.
pro-choice are there.
Yes. So that then brings me to the issue of where we suggest the court should draw the balance. And we say that when one looks at the actual nature of the competing rights, critically and carefully as the court will, and the justifications for adhering with them, then the balance does come down clearly, we would say, in favour of respecting the Article 8 rights of the service users. And we submit this for the following 5 reasons. Firstly, the interference with the service users' Article 8 rights is a substantial interference that has caused extreme anxiety and distress, in some cases providing long-term ongoing effect. And there's nothing they can do about it, apart from going to a different clinic, which begs the question, why should they, or would that be any better? The second point is that the interference occurs at the precise time and the precise place where they are at potentially their most vulnerable, immediately before and after having an abortion. And we would respectfully say, at a time when they are in most need of and entitled to privacy and respect. The third point I've already made, that the interference with their rights is exacerbated by the counter demonstrations. The fourth point concerns the interference with the protesters' rights. The fourth point concerns the interference with the protesters' rights. There's a balancing it. The first point, as I say, this is not a contribution to a debate of public opinion. Secondly, the order does provide for a designated area in view of the clinic, and within that designated area, anyone may pray, may engage with any service user who wants to engage, may give out leaflets. It is correct that it is further away. It is correct that the numbers of persons there are limited and the activities that are permissible are reduced. But nonetheless, this is not a prevention on the exercise on their rights, it is a restriction. Indeed, my ladies, there is nothing preventing the protesters from crossing over from the designated area, walking about 5 metres down Colmington Road, which is outside the safe zone, and then engaging in any activity they may wish without any control. Just the map is called under page 232. I don't take you to it, but if one looks at the designated area, one will see that just to the north and west of it is Colmington Road. The zone ends immediately there. And so there is nothing to prevent those who wish to hold large-scale prayer vigils whenever they want not more than 100 metres away from the clinic which is conducting the activities that they take issue with. The final point as to the restriction on their activities is that it is limited to a period of 3 years, that is the life of the order, and although there is power to renew it, that would need to be subject of a review and obviously the subject of consideration of all of the convention issues that arise. And the final point we make as to the court's balancing exercise is this. If it is correct that the rights enshrined by Articles 8, 9, 10 and 11 are designed to protect minorities against majorities, the weak against the strong, and the individual against groups, then we would respectfully suggest that the rights of the individual pregnant woman wishing to access her lawful abortion requires the protection here. Lord, that is the submission of proportionality. There are two further points to make before we turn to the last round. The first one...
We can meet to stop.
Sorry.
How much longer do you think we're going to be?
I'm going to be another 5 minutes on this ground, and then on ground 6, Miss Bogle is going to make the submissions. How long will you be?
How long does Miss Bogle think?
My lord, I'd estimate 30 minutes.
Thank you very much. Then we'll need to get it to it.